Time served.
All right,
I don't
Judge.
need it. Mr. Massengill, would you please raise your right hand to be sworn? You swear the testimony you give before this court is truth, so help you God. You want to enter a no contest plea of possession, control of substance without prescription, third-degree felony, correct?
Correct.
You can put your hand down. Are you aware of the rights you're waiving by entering this plea?
Yes.
Anyone force you or threaten you to enter this plea?
No.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work your attorney did for you, Mr. Williams?
Yes.
Court finds the plea is freely and voluntarily entered. Court accepts it, sentences you to credit for time served, judge guilty, 615 court costs. Okay?
Yes, Your Honor.
No probation, just, all right, thank you.
Thank you. Okay.
Next case is 24 CF 1329, State versus Trevor McDonald.
Come stand over here next to me, Trevor. And here, that's from Mr. Massengill.
Charged with possession of drugs without prescription and narcotics equipment possession, third-degree felony, first-degree misdemeanor.
Judge, I'll enter a plea of not guilty on his behalf. Request 15 days for any pre-arraignment motions.
All right, August 26.
Thank you, Judge. With your other cases, Mr. McDonald. Okay? And I'll come out and talk to you again.
When, August?
August 26th is your next court date.
Yes, sir.
Next case is Russell Bernard McLaughlin, 24 CF 1304.
Mr. Massengill, here, that's your copy, sir.
Thank you very much.
Russell McLaughlin. Charged, Mr. McLaughlin with possession of cocaine, third-degree felony, possession of narcotics equipment, first-degree misdemeanor.
It's a DOC offer, Judge.
Did you say DOC? What I had was 120 days county jail.
I was mistaken. It's 120 days county jail.
All right, we're not going to take it at this time, Judge.
All right.
Enter a plea of not guilty on his behalf and trial by jury, 8/26.
August 26th.
Thank you, Judge.
Next case is State versus Larry Jack Miller,
Take that.
24 CF 1399. All right. Charge is sex assault, 18, over 18, what is it?
Judge, State followed the information on it earlier today. I've already met with Mr. Miller. We're going to enter a plea of not guilty on his behalf, 15 days for any pre-arraignment motions, and demand trial by jury.
All right, August 26th. Okay?
Thank you, Judge. Yeah, that's your copy.
Next case is 24 CF 1357, 24 CF 1358, State versus Jeffrey Moore.
Judge, Mr. Moore's already on the docket for one case.
He's got 3 cases.
Yeah, he's got 3 cases now.
I got a global offer.
Well, we
It's-
have one as well. I kind of doubt they're the same. They're the same thing. Ours is time served.
It's not that. It's not even close. It's DOC.
We won't be accepting that then. We've got a bond hearing scheduled for you next week, okay,
All
next
right,
Tuesday.
August 26th, and then a bond hearing on July 30th, right?
That's correct, Judge.
Okay. Is there anyone else here for arraignment?
Yeah,
What's DOC?
state prison.
Anybody back there for arraignment?
I have one other inmate, Judge, from this morning as well. Mr.
Okay.
Davis, we have an agreement ready to go.
And we've got Mr. Well, you may, we're planning on bringing him out at 2. The fellow from earlier, good. Fulikowski.
Davis?
Your Honor, Mr. Wilkes is before the court. He was before the court this morning for violation of probation, and the state has now made an offer in the case. The state said they're not willing to dismiss the violation of probation. They said they would be willing to reinstate with court costs of $100 cost of prosecution, $100 public defender fee, $50 application fee.
What y'all want to do? You want to take that? Pardon?
He said yes.
Yes, sir.
Okay. I don't have that case number in front of me. Y'all got a form filled out, a plea form?
No, Your Honor, he just stated it. 24 CF 87. What would like, I can write one up.
You just write one up real quick.
Okay.
Judge, while we're waiting on that, Mr. McLaughlin from this morning is here now. He was coming in from out of town.
Oh, man, I'm just going to get back to this job.
I've taken my
For
file
real.
back over to the office.
Damn,
I
it's
can
child
either run over and
support.
pick it up and
It's
come
making no
back.
sense. I'm being in
or
jail and
pass
can't
him
do
off
nothing.
Until another date. I don't recall if there was an offer in that or if we discussed what we were doing on it.
If my memory serves me correctly, that he has prior FTAs. This is a pretty old case, right? So the reason it's so old is because he doesn't show up
You
in
want
court.
to leave this today?
I'm sorry, yep. Unless your child support hold isn't
Even to
done.
that, Mr. McLaughlin,
I ain't
stand
on
up.
child support.
Right here.
So showing up late to court after not showing
That
up to
case was
court
dismissed.
is
That's why I was telling you.
rude.
Where'd he come from? Alabama? You drive down from Alabama?
Sure, why don't you come forward so that.
Did I issue a capias for him?
Yes, Judge.
Yes,
I'll
Judge.
recall it.
You want to set him for August 8th?
Well, hang on, let's see if let's take care of Mr. Wilkes and. All right, this is State of Florida versus Alonzo Wilkes, 24 CF 87. Mr. Wilkes, please raise your right hand to be sworn. You swear the testimony you give before this court is true, so help you God.
I do.
You want to admit that you violated probation?
Yes.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this plea?
Yes.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir. I'm
Well,
sorry.
I know they're not going
Right.
to give
I'm
you
sorry.
any marijuana or cocaine or anything back there, but I still got to ask you. Okay?
Yes, sir.
Are you happy with the work Ms. Rivers done for you on your case?
Yes, I am.
Court finds the admission freely and voluntarily entered. Court accepts, adjudicates, and reinstates probation. Under the terms he was under, $100 cost of prosecution, $100 PD fee, $50 application fee. Are you being held here on any other charges, or
No, sir.
well, he should be getting out today then, wouldn't he? Okay, you'll get out today, hopefully, and just check in with them over there, okay?
And, Your Honor, if you continue to waive cost of supervision.
Yeah, waive cost supervision, and so don't mess up on your probation, okay?
I'm not.
Okay,
Thank you.
all right.
Your Honor, the next case I have is Anthony Weeks, 24 CF 498. This was an add-on, Your Honor. 24
Okay.
CF 498 and 24 CF 1534. We've reached an agreement, if I may approach.
All right, 24 CF 498, 24 CF 1534. Mr. Weeks, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Absolutely, sir.
You want to enter a no contest plea to failure to report change of address, a third-degree felony. That's in 24 CF 498 and 24 CF 1534. Another failure to report change of address and failure to register within 48 hours of motor vehicle. Three third-degree felonies. So you want to enter a no contest plea to those charges, correct?
Absolutely, sir. That's correct.
Did you read and sign plea and sentencing agreement form?
Yes, sir, I
Are you
did.
aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
Sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir, I'm not.
Are you happy with the work Ms. Rivers did for you on your case?
Tremendously.
Court finds the plea is freely and voluntarily entered. Court accepts it. On 24 CF 498 and 24 CF 1534, you're sentenced to 18 months community control concurrent on each case and each count, $1 a day per ankle monitor. 415 court costs, $100 cost of prosecution, $100 PD fee, waived cost of supervision. And there's a PD application fee and $50 PD application fee in 24 CF 498. And you can do community service for your court costs if you want to, okay?
Sir?
Adjudicated guilty, all counts, both cases. All right, thank you.
Your mom's here. Your Honor, if we may recall Ronald Willingham. Your Honor, he is present and approaching. Your Honor, he entered a plea before the court. In speaking with probation, they feel, and they talked to me about, it's best at this time to have him withdraw his plea and have the opportunity to meet with an attorney and go over some things in more detail.
I have no objection. I believe he's asking for an incarcerative sentence, and I just want to go over the
Yeah,
case again.
well, I'll let you withdraw your plea if that's what you want. You want to do that?
Yes, and so if we could give him,
Some time to think.
yes.
I need some time to think about before I just take probation off, so I can think about
All right, I'll let you withdraw your plea and put him for August 26th, unless you can get it figured out sooner.
today. Okay, then can I come by your office tomorrow?
So tomorrow I'll be at the jail, call, and I normally do appointments on Wednesday.
All right, next case.
Your Honor, if I may, with Mr. Weeks, I'm sorry, GPS to be hooked up prior to release.
All right.
Thank you.
Yes. Your Honor, Tim Gibbs, I almost called myself Kim there for a second. Your Honor, Tim Gibbs on behalf of Mr. Timothy Davis Sr., 22 CF 1876, Judge, I believe we've reached an agreement.
All right.
It's out. Any questions? If that was what you'd like to do, please sign there for me, please.
Wednesday, 25th.
Yes, sir. If I may approach, Your Honor.
Mr. Davis, Timothy Davis Sr., would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God.
Yes, sir.
This is 22 CF 1876, State of Florida versus Timothy Davis Sr. You want to enter a no contest plea to the charge of driving license suspended or revoked, habitual traffic offender, third-degree felony, correct? You want to enter this plea? Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs done for you on your case?
Yes, sir.
The court finds the plea is freely and voluntarily entered. Court accepts it, revokes and terminates probation, sentences you to time served, and $100 VOP fee, $150 PD fee, adjudicated, guilty.
We'd ask for 180 days to pay that before going to collections.
180 days to pay it before it goes to collections, okay?
Thank you, Judge.
All right, thank you.
Your Honor, I think that concludes my business, if I may be excused.
All right.
Thank you.
Then we have this gentleman here.
Yes, sir, Judge. This is going to be Mr. McLaughlin from this morning. I keep saying Octavius. I think he's got it as, or it's actually Octarius.
Octarius.
Yeah, Mr. McLaughlin,
Right.
come, okay. Sorry. Judge, this is the PTI, fail-out. He was on pretrial intervention, he failed out. I talked with the state about it, and what the state was going to ask for was the same thing I was going to ask for, adjudication withheld and costs, just to get the case over with and resolved.
All right. What, you got a case number?
22
Judge,
CF 75.
he does.
So it's Octarius. What was the name?
It's
Tears.
Ontarius.
Ontarius. Ontarius McLaughlin.
McLaughlin, yes, sir.
McLaughlin. And he's entering a plea to what?
Well, he's not entering a plea, Judge. He's already pled. When he was put on
Oh, this was
PTI,
that.
he entered a plea.
Okay,
He's just
yeah.
here for sentencing because he failed out.
All right,
Recommend sentences of withheld and costs.
I'll withhold adjudication, sentence you to court costs, 180 days to pay it.
All right, sir?
Okay? Don't mess up. You were here, you were in jail for, no, you were at a PTI. Okay, I got you. Alabama going to have a team this year?
What you say?
He wants to know if you have a team this year?
Alabama got a team this year?
If Alabama does, are they going to have a decent team this year? I don't follow football. I went to
I ain't
Tulane
without
when
a
the Saints were the Aints.
Okay. All right, thank you. Don't mess up. Okay, thank you.
And we lost our own homecoming to Vanderbilt, for crying out loud.
All right.
I want nothing from good football.
Yeah. You got 180 days to pay it to the,
You need a ticket, right? You need something to say.
It'll take care of it.
Yeah, they'll give him something.
Yeah, she's. They do it as they're going. They don't do for money and stuff, they do it as they're going.
Oh.
Yeah, they can go ahead and assess it, yeah.
Just on the back.
Must be Polish.
I'm just gonna,
Do you have much left?
no.
Excited. Can I go first?
Oh, but I don't.
Because mine's not going to take.
Let me get your signature right there.
Is that your shred?
It is. It's a decent system.
You mind if I date that for you? Okay.
is there a, do we have on the 24 CF 1400 State versus Donald Earl Davis?
Yeah, we handled that.
We did that today already?
Yes, Judge.
Okay.
I can tell you what the result was.
Did he show up? Okay, that's all I need to know. Okay, Mr. Kulikowski,
Yes, sir.
we got the,
State's signing it now, and I'll bring it up along with the score sheet. It's for an adjudication, 6 months community control with the GPS. We ask that the GPS go through, is it probation or through, it's through y'all? Okay.
You're
It's,
sentencing it, right? Yeah.
right.
all right, this is State of Florida versus Alexander Kulikowski, 24 CF 886. Would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God. You swear to tell the truth?
Yes, sir.
Okay. Did you read and sign this plea and sentencing agreement form?
Yes, sir.
And you want to enter a no contest plea to failure to report change of address, failure to provide required information, and failure to report another change. Is that right? 3 counts? 3 third-degree felonies, is that correct, Mr. Williams?
That's correct, Judge.
Are you aware of the rights you're waiving by entering this plea? They're in this form.
Say it again?
Are you aware of the rights you're waiving by entering this plea? They're in this form, the
But you
right to a
understand
trial?
You know, it's not going to be a trial anymore. You're going to be waiving the right to the trial, to the rights that are associated with the trial. Do you understand all that, or you need a little bit more time with me?
I understand.
Okay.
All right, you understand the rights you're waiving by entering this plea?
Sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Court downward departs. The judge is guilty. 6 months community control, GPS through probation or pretrial services. Hookup before release, standard court costs, cost of prosecution, and PD fees. Adjudicated guilty, all counts.
Thank you, Judge.
All right, so just do that community control and stay out of trouble and register, okay? If you have any questions, you ask someone how to do that registering, okay?
Sir.
All right, thank you.
Yeah, you're going to need to talk with them. Judge, I noticed that Trevor McDonald that we handled earlier, he's got another case set for arraignment on the 8th. If the state's filed an information on that, I'll go ahead and arraign him on that as well. We can save the jail
What's
bringing
he
him back.
charged with?
On that one, it's a written threat to kill or do bodily injury. It's a second-degree felony, or we can just leave it on for the 8th. They may have already taken him back.
Well, you plead him not guilty, PD
Yes.
appointed, August 26th.
Thank you, Judge.
Next. Anyone else?
Judge, that's all that I have, except for I've got somebody on the 2 o'clock docket.
And we have some officers here for the 2 o'clock docket as well.
All right. Next case is Sexto Rivera, 22 CF 1214, 22 CF 1222. Motion to dismiss charges.
Your
All
Honor,
right.
good afternoon. I filed the motion to dismiss charges after the time for the speedy trial had elapsed. Let me go down this if you don't mind. Get the documentation for the state's response. The state responded I have put, not, that the email was wrong. And I have looked through, and yes, I understand that the email was wrong. She is absolutely right. The state is absolutely right on that. But, I'm not going to argue that, as I said, the state is right. But here, what I'm going to argue is the fact that I filed multiple motions, and if the state allow me, the court allow me, I can bring this over to you. So this is the one I filed, I know it's there, and this was the state's response. If you look through the system, I'm pretty sure you're going to find multiple, more motions that I filed, and the state has responded. And if you notice, the email that is on my motions is the same email that I put on the speedy trial notice, expiration of speedy trial. So how is it that the state was able to answer all those motions that I filed before with the wrong email, but this one, the state wasn't able to get to it. Furthermore, the state was supposed to provide me with all the information, and the state failed for providing me with all the information, that knowing that I am a pro se defendant. And also the state that I requested about approximately 13 continuance. And I know that every time I have come here to this court on my own pro se, I have never requested that. I have always stated I'm ready to do this. Let's do this right now. So if the attorneys that I hire did that with them, that's one of the reasons they're not here today. Also, the state states that I didn't place a demand for speedy trial. The demands for the speedy trial, Your Honor, if you allow me, is to be placed during the time period. And as per the speedy trial overview by the Florida court, it states the Florida is the court allow me, it states that the Florida Rule of Criminal Procedure 3.191 Alpha provides that the person charged with a crime by indictment or information shall be brought to trial within 90 days of their arrest if the crime charge is a misdemeanor, or within 175 days of their arrest if the charge is a felony. Now, the time begins when when the defendant is arrested or served with a notice. And although the rule requires the states to bring the defendant within the 90 or 175 days, the remedy for violation, assuming the defendant is charged within the speedy time trial, which I was, it's not self-excluding or automatic discharge. Instead, after the deadline expires, the rule provides that the defendant file a separate plea entitled Notice of Expiration of Speedy Trial Time, meaning that at no time I needed to put a demand for a speedy trial. All I had to do was to put that now and serve a copy to the prosecutor. The filing of such notice invokes two deadlines, subsection 3.191 P and 3, Papa and 3. Provides that no later than 5 days from the day of the filing notice, unless an exceptional circumstance exists, the trial should hold a hearing on the notice. Number 2, the rule provides that the defendant be brought to trial within 10 days of the hearing. If the defendant is not brought to the trial within the time period and no exceptional circumstance exists, the defendant shall be discharged upon motion of the defendant or the court. You have my motion. Your Honor, this is in your hands. The state has failed constantly. This has been, the speedy time trial was 175 days. That's 5 days short of 6 months. That has quadrupled, Your Honor. This has continued to destroy my health, my life. It has destroyed everything, knowing that all the evidence points to me to be the actual victim. This is all I have to argue, Your Honor. This
What does
is
the state say?
Your Honor, the court does have the benefit of the state's response, is that correct?
Yes.
And, Your Honor, in that response, I actually laid out basically the facts of the case. And I'm going to put the whole email thing aside for the moment. The facts of the case, Your Honor, the defendant does have a right to speedy trial, unless, under the subsection J2, the delays can be attributed to the defense. And I actually attached a case that specifically cites that, which was State v. Bowers, 1 Southern 3rd, 1120, and it says basically, if the delay in going to trial is attributed to the defense, then the speedy trial time period is deemed waived. As I stated in my motion, or in my response, there have been approximately 13 continuances. Those were done by counsel that was duly representing the defendant at that time. That was within their authority. They were acting on his behalf. Therefore, they are not unauthorized. They are authorized. They're considered continuances on the part of the defendant. So the state's position is that the original speedy trial time clock has in fact run. In order to restart the time clock, the defendant must file a separate motion or a separate demand for speedy, which he has not done. So the clock has not reset itself. It is not before the court to reset that clock. So the state's position
Well,
is...
I have Mr. Rivera scheduled for trial September 9th.
Birthday.
Is
We
that
have-
your birthday? Happy birthday.
We
Jury
have-
trial.
Okay, we had pretrial, I believe, originally on the 8/26 docket, would be his normal pretrial docket.
We can set him for docket day, September 3rd.
Your Honor, even if the state was right, my first attorney didn't even last 3 months with me. So if there were 13 continuance within the first 3 months because I fired the attorney right here, that means the state still have a lot of time. And even if there was a waiver, as the rule shows, for a waiver for speedy trial, at any time, the defendant may place the notice of expiration of speedy trial if the time for the speedy trial, which is 175 days, have elapsed. And as I stated, it has been that has multiplied more than 4 times, Your Honor. This has been nothing but creating harder.
The court recalls you've had 3 different attorneys. They've asked for continuances. I know I gave you a continuance so you go to a funeral or something in Puerto Rico.
I didn't go. I wasn't
Well, it doesn't
able to
matter
go.
if you win or not. You still wanted to go, and that was...
That was the only time I requested to be out.
You know what? I would love to dismiss anybody's charge that they're entitled to. I don't have any problem doing it.
Right now, I have showed that I'm entitled to,
You're
and
not entitled to it because you asked for continuances and then demand for speedy trial hasn't been invoked. But I agree with you. You've been here a lot. You never missed court. I never revoked your bond and put you in jail.
yes, you have.
You've always been respectful to the court. You showed up. So we're going to put you on the very first trial docket, and you're going to go to trial September 9th. Your docket day is September 3rd to make sure that that trial day we give you. The week of September 9th is appropriate for you and the state in case you have witnesses you need to subpoena. But be prepared for trial. Your motion for speedy trial discharge is denied because many...
Your Honor. Okay, that's the, I understand. I'll ask a question. I know I have the right to put a motion.
Are you going to get an attorney or not?
I'm not.
You're going to represent
I will
yourself,
not.
fine. You're intelligent.
No.
Your Honor, just to clear up the whole issue about the email, because we do still, if Mr.
Yeah, make sure he's got your correct
That's what I was going to
email.
say. There's actually on the clerk's site, my secretary's emails there, that's where we can always be served. And that will find me. The other ones have wandered to my email box from other people that happened to see them.
Yeah.
They were never properly served. And that was anything that I answered had wandered in. I just went ahead and answered it.
Make sure he's got the right email address, because I looked on the clerk's, I immediately saw where Mr. Rivera had used the wrong address.
My question is this. Yes, you can say that I'm telling you whatever, but I have no knowledge of the law.
No what?
I have no knowledge of the law. So,
Well,
obviously, I was...
you got to represent yourself or get an attorney, one or the other.
So, I also have the right to do a Ferrera hearing.
All right, let's have one right now.
I also have the email, Your Honor, if we need it.
Do you understand, Mr. Rivera, that you have a right to an attorney?
Your Honor.
And if you cannot afford an attorney, I have no problem appointing an attorney for you free. But I've tried that a couple of times because I really want you to have an attorney, but they say you're very well financially secure. You're retired, as I recall, they said you were a retired military veteran. You have a substantial income. You've hired a couple of attorneys.
And one of them was let go because I cannot make the payments as a state. I do not have the money. Although my properties are valued in however much, I cannot do anything because the person accusing me of this is my spouse. And Florida is a spousal state, so I cannot even refinance my own home, which is solely on my name because
All right,
she is...
let me ask, hang on one
please.
second. Mr. Williams, He's raised that issue a couple of times. that he
And I
can't-
actually tried there to refi, and I wasn't able
It's-
because she.
It's wise not to interrupt a judge.
I apologize, Your Honor.
He has raised that issue that he can't get any money to hire an attorney because it's tied up in divorce court. And the public defender's come back with, he makes too much money because he has assets or something like that. Is that correct? I mean,
Judge, I've never been appointed on him, so haven't done anything with his case, don't know what his finances are, but I've been in court when Ms. Rivers was arguing before and establishing that he did not qualify for representation by our office. The monetary figure, I believe, is keyed to the poverty line. It's above the poverty line, but it's tied to it and adjusts each year. And then also, there has to be no assets that could be liquidated that would provide sufficient funds to hire.
well, he's also disabled. He's a disabled veteran, I think, correct?
I am.
And he's getting substantial income from that as well, Your Honor. That does take his income up. And it also has, I believe, the truck, and there's a few other things, because I'm familiar with Ms. Rivers'
Well-
response as well.
You know, I've tried to appoint you an attorney.
Your Honor.
On the one hand, I'm trying to get you to trial as fast as you can, because you've always shown up for court.
I tried.
It's still 5 weeks away for trial.
If I may, I tried to refinance the home. Everything went through except the other party's signature.
Yeah.
So that was done. So-
I understand that.
So I am trying to do it again, and I'm on the same roadblock right now.
You filed a divorce, or
I
she's...
filed for divorce in 2018 when this woman falsely accused me of raping her and
All right, well, we don't need to get
So
into
I
that.
filed for divorce 2018. I've been trying to divorce her all that time. So I haven't been able to do anything. Furthermore, I cannot liquidate any asset of my property because it's her name is on it. She has to sign, and she won't. Now, I hired one. I put myself in more debt to hire Miss Goodens. And when the time came to actually pay more, I wasn't able to pay because I didn't have the money from my pocket. I had to make a loan to pay for the I guess the initial, and then I had to let her go right here with you because I wasn't able to make payment. And that's exactly the issue that I've been bringing. So,
What's your monthly income?
my monthly income is let me see, I get
There's actually a financial
40,
affidavit filed.
45.
Another case.
How much?
Your Honor,
If
it
you
looks
allow me, I
like...
will tell you exactly what I make.
Okay, go
I
ahead.
make about $4,300 from VA. I make like $1,500 for combat-related service compensation, and I make $1,700 for rental property.
And
Now,
how much,
everything-
you got child support payments?
Everything is tied up. That's why that's why I'm trying to get the house refinanced, because I don't even have money to go sometimes and get something to eat. And I'm not joking about this, I'm being serious. They're serious
I'm
about
not
it.
joking with you either.
Oh, no, I'm just saying,
I'm not
for
saying
things
you're-
that I'm not.
Let me ask you,
And all has been tied up because of this situation. I had to get attorneys, pay with credit cards, and now I'm paying all those credit cards, and I'm not able to get another attorney, which I had to let go because of this situation.
well,
I have done everything I can on my end. My hands are like this because the other party, because Florida rules.
Judge, I'm not privy to everybody's income, but from what he just stated, he's got more money coming in each month than most of the public defenders.
And state attorneys.
well, the thing is, how much child support are you paying?
On the child support is with the other parent, I believe it was $400.
400?
To 400. But then everything is tied up on the
Well-
debts that I got due to this case. I've been trying to get attorneys, I've been trying, I got, and then I'm not able to make the payments because everything is tied up. I'm paying the credit cards now that I got in debt to this. So I was okay. So I guess I can have a solution here. I don't know anything about law. Yes, I have filed a few motions, because I will read and I want to defend myself.
Who's the
But-
next, if I appointed an attorney on the conflict list, the first thing they're going to do is ask for a continuance.
But what about a hybrid counsel?
A what?
A hybrid counsel, Your Honor. Hybrid counsel.
What's a hybrid?
Standby? I think he's asking for.
Oh, a standby counsel. Oh,
Yes.
you want a standby counsel?
That way,
All right,
someone present.
but they can't advise you on what to do. You can ask them a question or two, but they can't stand up and represent you.
not in the actual court, but we can talk, in the office and how I can go about
No,
my
he can
case.
show up in court and sit there as a standby counsel. They can sit at the table with you.
And you appoint someone, so I can meet with him prior to.
They're going to ask, pardon? They're going to ask for a continuance, and so you're not going to get to go to trial on your birthday. Because they're going to want to know what this is all about.
Yes, and I'm fine with that. I'm fine with that. If I can talk to someone, if I
All right,
can.
who's the next attorney on the list?
I can talk to someone that
I
I can
got
bring
you.
everything to,
I'm trying to work with you.
and I appreciate it, Your Honor. If I can bring everything to that person.
But
and
the
that person
thing
can
is,
sit with me.
you can't argue with them too much, okay? Just a little bit. Because you argue with everybody. I guess that's what you want to do, but I'm trying to get you,
If I don't advocate for myself, no one will.
I wish y'all could just work this case out. You work out all these other
It's a
cases.
withhold probation offer.
Withhold and probation,
Well, ma'am,
they're offering a withhold, which means you don't
I'm
have.
going to show the evidence, and
That's
that
fine.
is all, that's is going
Well,
to say it
let
all.
me tell you something. You don't have to prove anything. They got to prove it, not you.
I know, that's the thing, that's exactly what it is.
I don't know what the evidence
The
is.
state has mentioned, Your Honor.
Hang on a second. I don't know what the evidence is or isn't. But they've offered a deal for you to have no conviction.
Now, this woman is going to lose her legacy for what she has done.
Lose what?
She's going to lose her legacy for what she has
Her
done to me.
legacy?
Believe me, Your Honor, I have
I don't know what-
her lying,
I don't know
have
what
her
that-
lying on record to the
Me?
court multiple
This is not about
times.
me.
Everyone,
I have, what's it called, the police lying on record. The reports doesn't even show what the body can foolish.
We have another hearing
hang on.
that we need to do. We have another hearing, there's professionals.
I understand, but I'm running this court.
Yes, sir.
So, yeah, I'm not
Mr.
going to take that deal.
Rivera.
I'm just not going to take the deal.
Okay.
Nah.
Well, who's the next attorney on the list? All right, Christopher Scott, I'll appoint as standby attorney. Now, he's going to ask for a continuance.
It's okay.
Okay, that's okay.
All I request is that I can meet with him with my
We're going
evidence.
to put,
talk to him.
where's Christopher Scott located? All right.
I guess he will be online. I can Google him up.
What we'll do is, how about setting him for pretrial August 26th?
That's fine, Judge.
Okay, maybe we can still get you to trial.
And
Since-
I'll make sure he has the contact information. I'll show him where to find it.
But also, Your Honor, I wanted to state that the state has mentioned a few times that since I'm doing this pro se, the evidence rule does apply to me, which is obviously to share the findings between both parties, except when the evidence I have is for impeaching someone, or actually impeaching her. So I don't.
She's not on
I know she's not in
trial.
trial, but when the evidence is showing that I'm impeaching someone, I don't need to provide that information to her. So,
Understand the prosecutor's not on trial. You don't have to prove anything.
but if I
though.
show that the prosecutor has been lying, then this will be a mistrial. If I can show that during the case.
I mean, if you can, you don't have to prove anything. The jury has to decide whether she has proven the case, not
It's okay.
you,
It's
okay?
okay, Your Honor. I appreciate
So-
everything you've done.
What's his name, Christopher Scott?
Mr. First God, I got his email.
Okay,
His
so
name.
we'll appoint him standby counsel. He may come in here and say, Judge, I've got another trial. I can't just suddenly drop. So you may be, and you said you don't care, so it may get continued.
Okay. few more days, I mean, already it's been, what?
Well, I mean, you're not in jail. I let you out on bond, I guess you're on bond.
Oh, another one that I wanted to state. I was arrested due to warrant that was signed by you at the state's request, which was a double jeopardy bond, but the bond was revoked.
Well, you're out
Right,
on, you're
so
out on something.
I was arrested before the bond, I mean, after the bond was revoked, right? And this actually have these charges revoked completely, and those charges were dismissed. The misdemeanor court dismissed those charges because there was no probable cause. And now I had to pay again because of this false arrest. And now I have to put everything again on another new bond, pay everything again because the false arrest that
I was with Ms. Goodson, I don't know about all that, but I didn't put you in jail. I let you stay out. And so we will see you on August 26th.
August 26th.
I'm looking forward to you trying this case.
Thank you, Your Honor.
You might want to wear a coat and tie. And
I mean, I need help dressing.
you need help?
That's
Well-
why my girlfriend helps me.
All right, we'll have
I can't even tie my shoes.
How many witnesses do you think you're going to have, Ms. Basso?
Quick look, Your Honor. It's been a while.
I don't even have the witness list.
Well, you haven't filed a demand for discovery, sir. It's a long list, but I know I'll be cutting it down, Judge. I think it'll be a two-day trial, I would say.
Two-day trial?
To give him time to do what he needs to do, I think it'll be about a two-day trial.
All right, and so we'll have a FREDA hearing. You're going to have standby counsel anyway, but he can tell you things to do. He can't stand up and represent you, but he can be there to ask. And the court's going to tell you certain things, like how many strikes you have and that kind of stuff. But you're going to need to think about this offer. I don't know what the evidence is.
Let me ask first, what does that mean? The offer that you, I mean, what you offer, what does that mean?
What does it mean? It means that you don't have any kind of conviction. She's not on probation, right?
No, it would be a withhold and probation, Your Honor.
How much?
I'd be fine with 3 years with a no-contact order, mental health eval, and there might be a couple other conditions. But it would be something, and I'm glad, I will discuss it with him.
See if you can work on that.
I mean, I'm.
He's a disabled combat veteran. Are you a combat veteran?
Yes, I am a combat veteran, and I do my mental health that constantly without stopping. Prior to this and after this, I have no contact with these people whatsoever. As I stated, I've been wanting to divorce this person since 2000.
Yeah, he don't want to have contact with her.
You know, I need my child, but I was falsely
Let me
accused of my
just-
child.
Hang
So
on one second. Think about this. He's been to court. I know he was coming to court before I moved to this division. He's been to court dozens of times. He's a combat disabled, I believe, combat disabled veteran, correct?
I am. Yes, I am.
He's going through a divorce. I don't know if any of y'all have been through a divorce, but it does financially make things difficult
Your
for
Honor,
you.
if I may briefly, we did actually, Ms. Gooden had approached me about vet court. And I actually sat down and met with Mr. Rivera, not this Mr. Rivera, Mr. Ed Rivera, to discuss their plans and what they had, that they thought they could put in place to assist Mr. Rivera in getting to the other side of this, basically. And it was very favorable. I thought we really had to, he spoke favorable about what we could put together. And I told Ms. Gooden, absolutely, I'm 100% behind that idea. If Mr. Sixto Rivera would like to work with Mr. Ed Rivera in vet court, I thought that would be great, because I think that would get everybody,
Would the charges be dropped?
at the end of it, they would go away. But
The
he'd have to
charges would
complete
be
everything.
dropped? You
And we
just-
had talked about that.
you would
and
meet
then
with
he-
Mr. Ed
he declined.
Rivera.
You guys allow me for a second. Yes, that did happen. I was in jail because of the false arrest that was dismissed. And Ms. Gooden did give me information about VECCOR, but I argued with Ms. Gooden because the information didn't sound right. When the time came, she told me that if she had provided false information, she was going to put a thing, I guess, and a complaint against the bar, on the bar against her. When the time came, the information she had provided was not the case. So when I ended up actually going to vet court, and they actually got with me and talked to me, the psychologist there, the first thing he told me is like, man, I don't think you need this. You have done everything and more that we will ask you to do. You don't need more supervision. This looks exactly how it is. It's just a marital situation that has gone freaking crazy.
All right, set vet court aside. Let's set that aside. All
I'm just
right,
saying, we were trying to
I
work it
got
out.
you. But, let's think about something else. A withhold and,
I still have to watch out for the victims, Judge.
I know,
But
but
I'm willing to work with
check with the
people.
victim, see what you can work out.
Can I ask the court this? In your experience, and this is just from my understanding, because I'm always saying that one is more than the other, one is worse than the other. To me, sexual abuse, rape, or child, whoever, that is horrible. That's bad. Now, strangulation, on the other hand, although it's bad, it's not as bad of the sexual assault, against anybody, mainly children.
This is not any kind of.
No, I know. What I'm asking is, in the court's opinion, what charges, what are allegations are worse? Sexual assault or a battery like this?
You're not charged with.
Just for me to know, just for my knowing, just
You're
my.
not charged with sexual assault.
So, I know I'm not, Your Honor, because I proved that the person who accused me of that was lying.
What we're going to do is, you're going to check with the victim and see what we can do.
All the victim wants is to take the child away.
Pardon?
All the victim wants is to take the child away and steal from me, which she did with the help of the state.
All right, well, check with the victim, see if you got something we can offer, or you can offer him. And we'll set it for August 26th, and you got Mr., is it
Mr. Scott.
And
Thank you.
see what we can do.
Like I said, thank you, Your Honor.
They're offering a withhold, which means no conviction. And that means no conviction.
You are,
And no jail time, no prison time, no nothing, just some
you're
probation.
innocent. It's bad to give up to the masses. Actually, Exodus 23:1, it says, does not file false report, and you shall not join the masses to do evil, doing, or to raise false reports. So I will not just join the masses. The Lord wants me to fight for the truth, and the truth will come out.
I
Your
think
Honor.
Exodus 14:14 is something like stand silent before the Lord. So
I do stand silent.
I like that. I like that one too. Stand silent. Okay, I hope you do well, and I hope this works out for you. If it goes to trial, we got a visitor back there, huh? All right, is that one of those
Giant Schnauzer.
dogs that, what do they call them?
Service dog.
Service dogs? Yours or hers?
Mine.
Yours? I guess he'll be able to sit at the council table and help you. I've actually had dogs sit, I've actually had dogs
And
sit.
Mr. Mayor,
I've had I kind of need one. I need one. I need a service dog. I wish y'all could work this out. I really wish y'all
Thank you,
could,
Your Honor.
I wish y'all could work this out, and I hope you
appreciate
do.
everything.
Ms. Basso,
Judge.
I talked to the victim. Mr. Rivera knows.
Give you this stuff here.
Will you be willing to sit with me?
I don't,
State Attorney's Office, but I will have to figure out whether or not he wants to stand by counsel there. I'll definitely have someone else.
yeah, she can, she needs to, y'all see what you can do.
We'll figure it out.
But Mr. Rivera,
I'll give you the information so you can get what you need.
August 26th.
Thank you, Your Honor.
Okay, send me an order on those, send me an order on those motions denied. That dog's well behaved. I didn't know there was a dog there. All right, we got Mr. Sprouse, we got officers, Mr. Sprouse.
Yes, Judge.
What case is that one?
This is Michael Johnson.
Johnson?
Yes. 2019.
Sorry, officers, that it's just, sometimes y'all have difficult arrests. Sometimes I have difficult.
Mr. Johnson, come have a seat.
Michael Johnson, this is a VOP hearing?
Yes,
That's
Judge.
correct, Your Honor.
Violation of probation.
All right.
It's a technical violation, Judge. What's alleged is that the defendant used intoxicants to excess. So first, I'm going to call Officer Farnsworth from probation.
Officer, would you please raise your right hand to be sworn?
I do.
Thank you. Have a seat. All right, go ahead.
Sir, please state your full name for the record.
Matthew Farnsworth,
And what's your occupation?
correctional probation specialist.
How long have you been a correctional probation specialist?
In September, it'll be 1 year.
Are you familiar with the defendant, Michael Johnson?
Yes, sir.
Why are you familiar with the defendant, Michael Johnson?
I supervised Mr. Johnson starting in September 1st last year.
So is this one of your first cases that you got?
He was already on supervision when I took over the caseload. He was originally supervised by Officer Malcolm Harris.
Have you had conversations with Mr. Johnson?
Yes, sir.
And have you gone over the terms of probation with Mr. Johnson?
Mr. Harris instructed him when he first got put on.
Objection, hearsay.
That's admissible in a VOP hearing.
Yes, sir, it just can't be
Overruled.
based solely on it.
Overruled.
He was originally instructed when he was taken by Officer Harris. And then when I took over the caseload, throughout the check-ins and everything, I would talk with him about different things. And one of the things is his drinking, because a couple times that I had come over to his house, I noticed multiple beer cans and stuff. So I had a conversation with him about his drinking.
And why would you have a conversation with him about his drinking?
While it wasn't illegal for him to drink, one of the conditions is to not have intoxicants to excess. So I would say, hey, make sure you're not having too many. You need to make sure that you're able to coherently control yourself.
Do you remember when that conversation occurred?
I do not.
How many times did that conversation happen?
Probably one or two.
Do you know why you're here today?
Yes, sir.
What's the violation for?
The violation was currently for drinking to excess, but it stemmed off of a new law violation that was written by Crestview PD.
I have no more questions, Judge.
Mr. Williams?
Were you present that night?
I was not.
All right, and the night in
Objection
question
outside of
is-
scope.
Are we talking about the new law violation?
We're talking about technical. The new law violation has been dismissed, and I didn't ask about whether
Okay.
he was there.
Sustained. You're asking about a case that's been
You
dismissed?
have no personal knowledge of whether or not he was intoxicated on March 5th of 2024, do you?
Personal knowledge, no, but I
Okay,
base
thank you
off
very
of
much.
the,
Sir, it can be answered with a yes or a no. A yes or no suffice.
I asked for the witness to be able to answer the question.
They can redirect, and they can ask him what else he, needs to provide. But cross-examination, if it can be answered with a yes or a no, I can cut him off.
I think he said no. Redirect?
You said you don't have personal knowledge of the incident. What knowledge do you have?
My knowledge is based off the arrest report that I received from Crestwood Police Department.
Okay, thank you. You can step down. Thank you, sir.
Thank you, sir.
Next witness.
It calls Officer Minifield.
Mayfield?
Minifield.
Your Honor, as the officer approaches, may I be excused?
Uh,
I'm not going to use her as a witness, Judge.
I can stay,
Yeah, you can be excused. All right, would you please remain standing, raise your right hand to be sworn?
I swear.
Please state your name for the record.
Yeah, it's Officer Sam Minifield,
And where are you employed?
Crestview Police Department.
How long have you been employed?
1.5 years?
Do you have any prior law enforcement experience?
No, sir.
Any military?
No, sir.
Do you recall the evening of March 5th, 2024?
Briefly, yes, sir.
And on that evening, did you come across one Michael Johnson?
Yes, sir.
Is he in the courtroom today?
Yes, sir.
Can you point him out and describe something that he's wearing?
Mr. Johnson in his orange jumpsuit.
May the record reflect.
All right, it reflects.
Where did you come across Mr. Johnson?
Part of my direction, I want to say it was just south of actually this courthouse here in the gazebo. I made contact with him after I was dispatched to reference a Fish and Wildlife officer requesting our assistance.
Okay. Do you remember the officer's name?
Forgive me, I want to say it was a Velasquez or he was a Hispanic gentleman. I don't have the report with me, sir. I don't remember his
Why did he
name.
call you over?
He originally requested our assistance because he advised, again, bear with me, that he had a female subject with him doing a ride-along that evening, and when he went to go have her depart from the parking lot where he dropped her off, he and the Fish and Wildlife officer and that female had witnessed Mr. Johnson urinating at the gazebo. And because it's our jurisdiction, I can't stipulate why, as an officer that he is sworn in the state, he didn't handle it himself, but he did request our assistance, and we responded.
Because you have jurisdiction
Yes, sir.
in this area.
Yes, sir.
Okay. And you arrive on scene at the gazebo. What happens next?
Once we arrived, he briefed, myself and fellow backup officers arrived, and he briefed us on kind of what was going on. I've had contact with Mr. Johnson before when he advised that, he appeared to be inebriated, and he had witnessed him urinate in the gazebo. I was like, understood the situation. I advised him I'd have to speak with Mr. Johnson and take the facts in consideration of what actually happened. And then I approached Mr. Johnson.
You've been trained on DUI.
Yes, sir. I have a couple different certifications.
And what are those certifications?
The highest I hold is advanced roadside impaired driving enforcement.
Okay. So you have training on normal faculties?
Absolutely, sir.
So what's a normal faculty?
Any way you can
In relevance, the question is not whether or not his normal faculties were impaired, but whether he was intoxicated.
Overruled.
Yes, sir. Just as you are appearing in this courtroom today, and so am I, we can speak, talk, walk freely. We can understand what each other is saying, and it does not seem to be out of the ordinary. That is a normal faculty.
How about judgment? Is that a normal faculty?
Yes, sir.
Okay. So someone's judgment on where to urinate, that would be an indicator whether somebody's...
Yes, sir. If somebody had impaired judgment on where they have to urinate, that would be considered a clue on my intoxicated person investigation.
Where exactly was he urinating?
The suspected urinations,
Objection, the officers testified that he didn't see the urination. It was another officer that saw the urination. He's asking a question that's
I can
not within
rephrase.
this officer's knowledge.
Right, rephrase.
Where was the defendant's alleged urination?
if you're looking at, sorry, from the backside gazebo moving forward, there are two entrances to that gazebo. As you walk into it, it's a little lighted hut, and directly to the left of the last exit to that gazebo, the suspected urination spot was right across the railing and onto the concrete floor where there was a wet stain.
Other than the other officer that was present, is there any evidence that somebody urinated or that the defendant urinated where he's suspected to urinate?
Yeah, it was a wet stain in the ground that it did have the smell of urination to it.
And was the gazebo covered?
Yes, sir.
Was there anything else that was wet?
No, sir.
Any other indications or indicators of impairment?
Yes, as follows. Mr. Johnson appeared to have several indicators. Mr. Johnson had a slurred speech. He had watery and bloodshot eyes. He could not properly balance. He swayed continuously. As well as Mr. Johnson had a heavy odor of alcohol emanating from his breath.
But were there other people around Mr. Johnson that could have smelt of alcoholic beverage, or was he the...
I would venture to say, again, this is from my best memory, that the fellow officers that were out there with me, including the Fish and Wildlife officer, could also testify to that.
But the Fish and Wildlife officer didn't smell of alcohol.
I did not ask him, personally.
I have no more questions, Judge.
Yes. Stray dogs in Crestview?
Say that again?
Do y'all have stray dogs, canines? Like the fellow that was in court just a little while ago. Do y'all have stray ones in Crestview?
I would venture to say we see those without owners.
Okay. Now, the wet stain was on the ground?
Yes, sir.
It wasn't like this high up, say 3 feet up or 4 feet up. It was on the ground.
My apologies, sir, if I had described that more clearly. There was you could see it's a wood railing. There was wood stain on the railing as it trickled down, leading to the puddle onto the floor.
All right, so it was urinated on the railing.
It's a railing, and you have spokes, wood spokes, so many inches apart from one another for decor, and that lead
So it
down.
was the wooden spokes that were urinated on.
It's wooden spokes that lead down to the trail onto the wet concrete.
Right.
Yes, sir.
You ever seen a dog pee on a tree?
I have not watched a dog urinate on a tree, sir.
You ever seen a dog pee on a bush?
Yes, sir.
Male dog?
Yes, sir.
I don't think any dogs are on trial here. I mean, what is this all about?
Did you obtain a sample of the suspected urine?
No, sir. We don't have much of a way to actually collect that.
All right, so you don't even know if the urine was canine urine or human urine?
No, sir.
Okay. And you yourself didn't see anybody pee on anything?
No, sir. It's fellow officer rule.
Well, sir, this is a violation of probation hearing. It's not where you're trying to justify a search based on what another officer saw. The fellow officer rule doesn't apply here.
What's your question?
Do you have any knowledge? Did you perform any sort of field sobriety exercises or obtain any breath samples or otherwise test to determine the blood alcohol level of Mr. Johnson?
No, sir. We were not conducting an intoxicated person investigation.
Okay. Do you know how Mr. Johnson normally walks and talks and acts, and whether he normally slurs his speech somewhat?
Sir, may I ask if this is when he's sober or inebriated?
When I said normally, I'm assuming when he's sober. Okay, normally, like you were testifying earlier about normal
Yes,
With the
sir.
prosecutor and yourself?
Yes, sir. I've never actually had contact with Mr. Johnson when he was not inebriated.
Okay. And since you did newly cancel, there was no attempt to actually isolate the urine or the suspected urine, suspected human urine, because we don't even know if it's canine or human, with Mr. Johnson?
No, sir.
Okay. I don't have anything further from this witness, Judge.
Next witness, thank you. Sit down.
Thank you, sir.
Call the defendant to the stand.
Mr. Johnson.
Sir, they can ask you some questions, they just can't ask you any questions that would tend to incriminate you in a crime. So if they ask you about whether or not you urinated or did anything that would have been punishable under that misdemeanor case, since it was dismissed, I'm going to object to it. So go ahead and take the stand, okay?
Just as a preface, Judge, urinating in public is not a crime. So they would, if I ask them about it, it's not incriminating.
All
So
right.
they're alleging that it was, he was arrested and charged with breach of the peace, which is
He's not charged.
All right.
Well, it doesn't matter whether he's charged, whether or not it would implicate.
And my understanding of this is he was not supposed to be drinking alcohol on probation. That's what we're trying to go to. Is that what?
No, sir, he's
In
allowed to drink
excess?
alcohol, just cannot drink to excess. So the question here is going to be whether or not he drank to excess.
What's the other allegation? That he was
The
arrested?
other allegation
and-
was
And the charges were dropped?
that he committed a breach of the peace by allegedly urinating outdoors.
And
I
the
guess.
state's not, that's not a crime that the state has said.
Nothing else.
So
has been-
he could drink, but not to excess?
Yes, sir.
That's right.
It's under the standard conditions of probation. You didn't have a special condition prohibiting him from drinking at all.
Is he on jail on this VOP?
Yes, sir. He's been in jail since his arrest.
How long has that been?
Since March 5th, Judge.
How much longer has he got to go on VOP, on probation? How much longer has he got to go on probation?
Maybe
May the 4th of 2026.
He can drink, but not to excess. Is that what that's what
Yes,
the
sir.
allegation
The
is?
standard condition of probation is that you can drink, but not to excess. If you want somebody not to be able to drink at all, you have to impose a special
All right,
condition.
go
of
ahead,
alcohol.
Mr. Sprouse, if you want to ask him something.
Yes. Mr. Johnson? He needs to be.
Oh, I'm sorry. Would you raise your right hand, please, to be sworn, Mr. Johnson?
Do you swear from the testimony
Have a seat.
Please state your name.
Michael Johnson.
And where you work.
I don't work. I'm on disability.
Mr. Sprouse, the court reporter needs to pick you up.
On May 5th, 2024, what were you doing?
May 5th?
Sorry, March 5th, 2024. The night you were arrested.
I was at home. My lawyer's secretary called me and said, I'm on disability. My lawyer's secretary called me and said my check was in. My check was going to the office because I was found incompetent. So my disability check was going to the lawyer. I went to his office, got my check. My bank is Synovus, which is up by the high school. I went to I went to the lawyer's office, got my check, went to the bank, deposited my check. Because of the amount, they said that there'd be a 24-hour hold on it. but they gave me a little bit on it because
How did you
That's-
get to Synovus?
walk, and I mean, I've got, as you could see when I walk, I have a bad leg. My legs,
Did you drink that day? Do you remember drinking?
on my way back from my bank, I stopped and got 2 beers.
How big were the beers?
Them, I want to say like an 18 ounce,
So like tall
or,
boys?
yeah,
Would you call it a tall boy?
Yeah.
You had 2 of them
I had 2 of them
on the way back.
on the way back.
So how long did it take you
It was, I mean, I say, with my condition, sir, and my leg, it takes me about an hour and a half to get from my place to the bank.
to drink? So an hour and a half, 2 beers,
Yeah.
2 tall boys.
And see, sir, I don't know if I'm allowed to say this. I've been an alcoholic, a heavy alcoholic, for at least 40 years. You know, so I mean, 2 beers is not gonna make me, you know, what's that word, inebriated?
Why did you make the decision to urinate on the gazebo?
Objection, he's asking essentially 2 questions. It's like, have you stopped beating your wife yet?
Well,
He's not admitted that he made the decision to urinate on the gazebo. He'd have to ask first, did you urinate on the gazebo, and then ask why.
I can rephrase, Judge.
thank you.
Do you remember urinating on the gazebo?
No, sir, I do not. I wasn't there that long. As I was walking up to the gazebo, I was dialing my girlfriend's number to let her know to be ready, because I was going to take her to Fat Boys on Main Street for lunch. She was hit by a car not too long ago, so I don't like her walking by herself if she don't have to. And in the middle of me dialing her number, as I was walking to the gazebo, the law showed up. So I wasn't even at the gazebo that long. Because where I live, I pass by the courthouse over there and go over by Burger King and go
Were you
down.
charging, forgive me if I interrupt, were you charging your ankle monitor?
I think I was.
So,
I mean, I just plugged it in, and that's why I was saying I was calling my girlfriend to let her know to be ready. Mr. Farnsworth knows her.
so your testimony today is that you were not at the gazebo long enough to urinate, but you were there long enough to charge your monitor and call your girlfriend.
All I did, I mean, I got there, I plugged it in, and I called her.
I have no
And
question.
as I was dialing her number, they showed up.
All right,
have
Mr.
no
Williams.
So you didn't completely charge your monitor,
No, I didn't.
you were just starting to.
Yes.
Okay. I don't have any further questions.
All right, thank you. You can step down.
State rest, Judge.
The allegation is he drank to excess,
That's correct, Judge.
and he was out until he got picked up on his VOP.
Yes, sir. I mean, I'm only seeing, I'm seeing a 5/26/22 VOP that our office had on him, back in '22, where he was restored
Has he
10
been,
days county jail with credit.
He's already adjudicated.
Yes, sir.
Court finds he violated probation. Court sentenced him to time served and reinstates him in original terms of probation. Okay?
Thank you, Judge.
Thank you.
GPS, Your Honor.
GPS.
Be hooked up prior to release.
Yeah. I'm going to release you back on probation, Mr. Johnson. I found you guilty of VOP. Don't be drinking too much. You don't know what you're doing. You're peeing out in the public, okay?
Yes, Yes, sir.
Time served, reinstate probation, original terms, GPS monitor, affixed before release. Okay? And do what Mr. Officer Farnsworth tells you to do. Make sure you obey the probation, okay? They're not trying to hurt you, trying to help you get through probation.
Yes, sir. I have,
Yes.
am I allowed to ask a question?
We add no drinking, so we're not here on similar issues.
No. If he had done something violent or hurt somebody